Starting in 5 seconds. Learned Council has submitted that the amendment in question changes the identity of fundamental rights while omitting to take into account the crucial factor that social backwardness was a cause of economic backwardness and not its consequence. While relying on the decision in Saurav Yadav and others, which held that open category is open to all and horizontal and vertical reservations are methods of ensuring representation in public places. He has argued that the right to equality of the persons belonging to SC, ST, and OBC communities is impacted by reducing their seats in open category. He would reiterate that rule of equal status shall apply while reading Article 46. Lastly, he has submitted that confining each social category to its extent of reservation would result in communal reservation, which in turn would result in breach of equality code and thereby damage the basic structure of the constitution. Learned Counsel referred to the physiology of the provisions under consideration and submitted that while Article 15 bracket 4 and 15 bracket 5 refer to the socially and educationally backward classes, Article 16 bracket 4 is directed towards backwardness and inadequate representation. According to him, the impugned provisions of Article 15 bracket 6 and 16 bracket 6 have left aside the key elements of social backwardness and inadequate representation while providing for AWS reservation. These provisions, therefore, are rather opposed to the spirit of the existing provisions. The Learned Council has again urged that Article 46 should be read under the rule of equal status and by excluding SC and ST and OBC communities. The said rule is violated according to the Learned Council, keeping SC, ST, and OBC communities outside of its scope and bringing in economically weaker sections within it was never the idea of Article 46. He has also submitted that no constitutionally recognized commission has been set up for determination of the financial incapacity or capacity of a candidate, as in the case of OBCs. Learned Senior Counsel has argued that there was no dimension of equality other than what was rooted in Articles 14 to 16 of the Constitution, relying on passages of judgments in Keshavananda which indicated that new dimensions of equality could be discerned having regard to new challenges. He has submitted that those observations were not endorsed by other judges in that cases reviewed in the judgments earlier. As a result, the amendment cannot sustain itself on the ground that it gives shape to another facet or dimensions of equality. A learned counsel has further contended that economic criteria cannot be the sole criteria for the basis of classification, and if it is to be taken as a sole criterion, Indrasani has to be revisited, which cannot be done by this bench of 5 judges case. Learned Senior Counsel in addition to the arguments already advanced, would submit that 10% reservation in open category in favor of forward class reduces the availability of seats in open category for other classes and communities, in particular the persons belonging to the creamy layer category in OBCs. This, according to him, would damage the basic structure of the Constitution. Learned Senior Counsel and the Learned Counsel, Mr. Sachin, have also made their submissions as intervener. All of their submissions, which are akin to the submissions already noticed above, need not be elaborated. However, in sum and substance, their additional submissions had been that the amendment in question, which states not more than 10% of the total seats in each category, has to be interpreted as providing 10% reservation for EWS in each category. One of the interveners provided the statistics as to the percentage of people working in each category to submit that the exclusion of SCs, STs, and OBCs is invalid as they are still inadequately represented in state services. Further, he submitted that the current strength of bench is not competent to overrule Indrasani case, wherein it was explicitly held that reservation cannot be based solely on economic criteria. Yet, further discussing the power of Parliament under Article 368, it was posited that the Parliament has the power to amend the Constitution by way of addition, variation, or repeal, and not by breaking down the basic structure of the Constitution. In part, challenge to the amendment in question, the learned senior counsel Mr. Gopal has taken a stance different than other petitioners and has contended that the amendment in question is violative of basic structure of the Constitution only to the extent of the words in addition to the existing reservation and which need to be severed, and that the rest of the part which provides classification on the economic criteria for extension of special provisions for the advancement of economically weaker sections, excluding classes already covered under Articles 15 bracket 4 and 16 bracket 4, was permissible. The learned counsel has otherwise supported the amendment in question on two grounds. First, that the insertion of the economically weaker sections is perfectly valid as a class for the extension of special provisions for their advancement, admissions, and for reservations in post. Stop.